for with the forum, and I'm joined by Brandon Irax-Edlin, my forum colleague. So I say hi to everyone, Brandon, please. Appreciate all his support to make this happen. Pleased to have what's a regular, almost quarterly Ask the Nonprofit Lawyer program. Once again, we're pleased to have Jeff Tenenbaum with Tenenbaum Law Group here with us. Welcome, Jeff. Thank you for being here today. Hope everyone is doing well as we're heading into the middle of summer. There's always lots of questions folks have. Some are evergreen questions, some are new things. And so let's just get to it. A number of you submitted questions ahead of time, so we're going to start with those. And then with time permitting at the end, if other questions come up that people have that you didn't submit ahead of time, we will hold space for that.
Well, so, we will have time because
yes.
This is all about your questions. So there's no, so start thinking about questions that you do want to ask.
Yes, thank you, Jeff, for that.
Including if you have follow-up questions on, the questions that were submitted in advance, please feel free to chime in.
Great. And the first question is, what can you share with us about shared or fractional employees? We'd like to hire a finance person for 3 days a week and contract them out for the other 2 days. Are there any legal concerns we should be aware of? And that was from you.
By the way, good to be with you as always. Every quarter, good to see a lot of familiar faces. So this question is an interesting one. It raises a few questions in my mind, a few legal issues, not necessarily concerns, but things that you need to address. One is that you have this issue of employees versus independent contractors. The issue has been around forever. It's both a labor issue, like U.S. Department of Labor and state departments of labor, as well as it's an IRS issue because there's tax implications. And there's a multi-factor test that's applied. It's kind of a different IRS test from the U.S. Department of Labor, but they're very similar in principle. And it's a test for determining whether someone can be an independent contractor or needs to be treated as an employee. It's a really important issue because there are a whole host of things like employee benefits and tax benefits and other things that apply to employees that don't apply to contractors. It's also much less expensive for a nonprofit to bring on a contractor than it is to bring on an employee for all of those different reasons. Employer share of payroll taxes and so many other things that come into play. Contractors aren't subject to any of those rights and benefits, whereas employees are. But the thing is, even if an individual, I'm just going to call him or her a worker, even if a worker agrees to be treated as a contractor, if in doing the analysis under the law, federal and state law, they are truly an employee, then that poses great risk to you. So, essentially, an employee is not able to kind of waive his or her rights and become a contractor. So it's really important that you and this is something that applies to all of your workforce. A lot of nonprofits rely heavily on contractors. To me, one of the biggest, there's all these factors in the analysis, but to me, the factor that matters most is the worker doing work for other organizations? Does he or she have other clients, or are they just working for you? Because if they're just working for you, now granted, the other factors come into play as well. I'm not going to get into the nuances of the analysis here. But if they're just working for you, even if it's on a part-time basis, a lot of people think, well, part-time equals contractor, whereas full-time equals employee. Certainly, if they're working full-time for you, it's virtually impossible to see how they could be treated as a contractor. But if they're working part-time, they might still be an employee. There is such a thing as a part-time employee. And so one of the issues that this question raises is if someone's just working 3 days a week, are you properly treating them as a contractor versus an employee? Obviously, if you want to treat them as an employee, that's fine, and that's great. There's no penalty there for giving them the benefit of that employment status. But if you did want to treat them as a contractor, then that's something you have to be cognizant of. And I would recommend you work with either an HR lawyer or an HR consultant who has a lot of expertise in this area to help you do that analysis and make sure you're treating them properly. But the other The other thing that I wasn't sure about for the question, I said we'd like to hire a finance person for 3 days a week and contract them out for the other 2 days. So I didn't know if that meant the employer is going to hire the person as a full-time employee, but then essentially lease them, to some other, say, related nonprofits or whatever to do work 2 days a week and
Yes.
be reimbursed for that. Okay, so
that is the plan.
Okay, I thought that was the case. And so I know the first part of what I just said wasn't really relevant to your question, but I figured
No, it's fine.
background for everyone for other situations. But yeah, so in this situation, then we don't have the employee versus independent contractor. They're an employee, they're a full-time employee of yours, they get all your benefits and all the other stuff that goes along with that. So it's no problem. And it's actually very common for nonprofits to provide management services to other nonprofits. We see it with a ton. We have hundreds of our nonprofit clients have like related affiliates and subsidiaries and things like that, where employees of one are providing services to another. Sometimes they're provided, some national organizations that have state and or local chapters will provide management services to the state or local chapters and get paid for that. Sometimes a larger organization will provide services like the American Hospital Association provides. Essentially, they manage a number of different smaller associations that are in the hospital space. And those organizations essentially live at AHA headquarters, and they pay AHA essentially like a management company, what's often referred to as an association management company, to provide those services. And so if, say the finance person, one of the finance people from American Hospital Association is, spending 2 days a week on the finances and accounting for that particular organization, they will get reimbursed by that organization for that. Now, and all that's fine. You want to do it pursuant to a written agreement, of course, like you would anything like this. Make clear that they're, an employee of yours. There are two other issues that come to mind. One is there's something called the joint employment doctrine, joint employer doctrine. What it says is that there are situations where you can actually have two, or sometimes even more, but usually it's two employers of the same individual, joint employers, and those individuals are called joint employees. And what that means is, even though the paycheck might be coming, say, from your organization, like you said, Philanthropy Ohio, the other organization where that person may be not physically working, but maybe virtually or whatever, and reporting to people there, they are likely going to end up being a joint employer. Now, your agreement will have language in there that says they're not a joint employer and everything else. But let's say, like, for instance, the other organization did something to, discriminate against or harass that individual, right? They can actually have liability as an employer. Even though you're kind of the employer of record, they're still exercising employment responsibilities and therefore can be deemed to be a joint employer and subjecting them as a joint employer to all of the protections of the and requirements of the employment law. So that's one thing to keep in mind. And the other thing is the taxability of the income that your organization earns from that management services agreement. The IRS precedent in this area is very split as to whether revenue from those situations needs to be treated as taxable unrelated business income.
Right.
There are some rulings in cases that suggest that if the management services are in a related field, that you don't have to treat it as unrelated business income. It can be treated as related income. But then there's some other cases and rulings that suggest, no, that doesn't matter, because providing management services is not, to other organizations is not in furtherance of your mission and purposes. Therefore, it's, the definition of an unrelated business activity, a regularly carried on trade or business that's not substantially related to your mission and purposes. So in some instances, it doesn't matter much, because usually, not always, you're just getting reimbursed for the actual cost of that employee. So even if you treated it as gross unrelated business income, you would net out and offset, the direct expenses, which would be all the salary and benefits and employment taxes and other good stuff. But still, you might have some concerns about reporting unrelated business income or having to, make quarterly estimated tax payments and all the other things that go along with it. So just something to keep in mind. Talk to your tax advisor, talk to your accountants about it. To see now if it's in a related field, maybe you just
we thought, Jeff, that it would likely be one of our members. So as a benefit of, one of our members, one of our foundation or funder members might need a part-time So if it were if it were one of our members, it felt to me like it wouldn't be UBIT, that we wouldn't have to worry about unrelated business
And
expenses.
yeah, these members are all nonprofits, I presume.
Correct.
Yeah.
They're all foundations.
Yeah. So listen, that's what I was saying at the end. Basically, I would probably just take the position that it's related income, right? You could possibly get challenged on it, but it takes an IRS audit to get challenged on that, and those don't happen very often these days.
Thank you.
Probably very little risk. We're not talking about a ton of money anyway, and I think there's a defensible position. The only way that this might come up is if, or more might come up more quickly or frequently, is if your auditors of your external financial statements, if they flag the issue and say that they have concerns that it should be treated as unrelated business income. That's where this issue usually comes the most. But I would take the position that it's related and just go from there.
Okay.
All right. So that's
Thank you,
a long answer to a
No, that was exceptional. Thank you very much. That was very, very helpful.
Sure.
Great, thanks, Jeff. The next question is also one that's not, this is one that comes up all the time. Can sponsors of a program be given access to other benefits such as free registration, exhibitor booth, et cetera, without it affecting their charitable gifts? So the sponsor is probably a foundation. We've heard mixed advice and want a clear legal parameter to share if possible.
So there's actually, we're primarily talking about federal tax issues here, tax exemption issues. Of course, there's other issues like, having a good contract in place with your sponsors and all of those sorts of things. But I presume the question is primarily focused on the tax issues. There's really two different federal tax issues here. One is, and you mentioned, Dave, maybe that was just a presumption that you presumed that the sponsor was a foundation. But the sponsor could well be a for-profit company, that provides products and services to foundations and, therefore is interested in sponsoring. That's obviously a very common construct in your world, I'm sure. So there's two different issues. One is, how does it affect the sponsor, the tax treatment for the sponsor? And then the other is, how does it affect the tax treatment of the income to your organization, the one that is the kind of beneficiary of the sponsorship? They're two different issues. So for the first one, we've got to separate out if the sponsor is a for-profit or a nonprofit. So if it's a for-profit, the issue is generally going to be one of tax deductibility, either charitable tax deductibility and or business tax deductibility. So let's say a sponsor is trying to take a charitable tax deduction for a contribution. As you all probably know, charitable tax deduction to donors, whether it's an individual or corporation, are limited by the value of whatever goods and services the sponsor gets in return for the gift, or the donor, I should say, gets in return for the gift. So usually in most sponsorship situations, granted, we're generally representing the nonprofit, not the for-profit, but I don't believe in most situations that corporate sponsors of nonprofits are trying to take a charitable tax deduction for their sponsorships, because they're generally getting the value, something of equal value in return, right? All the sponsorship benefits, the acknowledgement, the recognition, the whatever else they might be getting. Now, granted, they might be able to make an argument that the benefits they get in return are not equal to and are something less than the value of the sponsorship dollars. But regardless, most corporate sponsors, in my experience, take a business tax deduction, because business tax deductions are not limited by these issues. It doesn't matter the value of what they get in return. If it's an ordinary necessary business expense like marketing or advertising, then it's going to be fully tax deductible as a business expense. So, unless they needed it to come from, say, a pot of money that's limited for charitable gifts, that's really probably not going to be an issue for a for-profit sponsor. And for a nonprofit sponsor, they don't have issues of tax deductibility. So, I don't think it really matters, so long as they're able to do the sponsorship, and presumably they are, it's within their mission and purpose, then it really shouldn't matter if they got some of these other benefits in return, like an exhibit booth or discounts or free registration for staff. Now, on the second issue, talking about the tax treatment of the income to the nonprofit, the one that's the beneficiary of the sponsorship. That's where this gets a lot more interesting, from my perspective. So this has to do with unrelated business income again. So unrelated business income, and by the way, there's a pretty new article that I wrote all about unrelated business income tax and nonprofits that's on our website, and it covers this issue along with some other ones in great detail. I'd encourage you to take a look at it. And Dave, can you put the link to tenenbaumlegal.com/publications in the chat? And so like that article talks about unrelated business income tax, been around since 1950, says that if you're a tax exempt organization that engages in a regularly carried on trade or business that's not substantially related to your mission and purposes, then you're generally going to be taxed on your net income from that activity as unrelated business income, taxed at the federal corporate income tax rate, along with any state corporate income tax that might apply in whatever state you're located in. But there are numerous exceptions to unrelated business income. And the one that's relevant here, some of the more notable exceptions are like the exceptions for passive income, like dividends, interest, annuities, capital gains, the exception for qualified convention and trade show income, the exception for activities carried on principally by volunteers, the exception for royalties, like affinity programs, endorsement programs, things like that. A royalty is money that a tax exempt entity gets for the license of its intellectual property, like its name, logo, donor list, etc. And corporate sponsorship payments, which has been around since 1993 or 5, I think 95, since Congress enacted it. So there, the issue is the money that the nonprofit is earning taxable unrelated business income because it looks and smells like advertising, which is the most common form of unrelated business income, or is it exempt from UBI, unrelated business income, because it qualifies under that corporate sponsorship exception? And so it's important that you understand, so that corporate sponsorship exception, it's basically modeled after the Federal Communication Commission's rules for public TV and radio broadcasters. There, it's an issue of what they're allowed to do and provide to sponsors in terms of benefits. But it's modeled after that. What it basically says is that if you're a tax exempt entity, you're getting sponsorship dollars, and you're merely just acknowledging the sponsor's contribution. And you could acknowledge it by using the sponsor's name, logo, established slogans, link to their website, non-qualitative descriptions of the sponsor's products and services, things like that. You can have exclusive sponsorship arrangements, but what you can't do if you want to fit within the exception is include price information, qualitative language, like they're the best or they're the least expensive or they're most effective, no endorsement type language, other things like that. The article talks about all that in detail. And so if you want to fit within the corporate sponsorship exception, then you would not provide any of those they're not prohibited benefits, but they're just benefits that are inconsistent with the exception. But what often happens is in these arrangements, they're multifaceted. So let's just call it a corporate partner. And the corporate partner wants to have a sponsorship, say for maybe an event or just a website or maybe a golf tournament or whatever the case may be. But then they also want to get free registrations for a certain number of staff at your conference, and they want to have free exhibit booth, and maybe they want to get free ads in your magazine. What you want to do in your agreement, in that corporate partnership agreement, is you want to break out the income into the various buckets like you would do on an IRS Form 990. So, whatever, and first off, I should have said this up front. The corporate sponsorship exception does not apply and cannot apply in two cases. One is in periodicals. So like magazines, newsletters, journals, it cannot apply there. And the other place it does not apply is to your qualified convention and trade show activity. But that's okay because that's subject to its own very broad exception. So if all of this stuff is being done within the confines of a conference, it's probably all going to be exempt income under the qualified convention and trade show exception. But if some of the sponsorship involves, sponsor benefits that fall outside of a conference, but there's also going to be benefits at the conference. There's also maybe going to be, like we said, free registration, exhibit booth, discounts on certain things, and maybe advertising in your magazine or newsletter. You want to break it out and say, okay, this is the amount for corporate sponsorship. This is the amount for qualified convention and trade show revenue. For the exhibit booth fees and the registration for staff, that's all going to be exempt under the qualified convention and trade show exception. And then if there is any unrelated business aspect to it, like advertising in your magazine, then you would separate that out, and that would be the only part that you would treat as unrelated business income. So again, long answer to a short question, but very complicated area of the law, and I'd encourage you to take a look at that article, which should be somewhere near the top of the list there on the website.
Great. Thanks so much, Jeff. Appreciate that. The link is there. This next question from a member who says that a person that they work with in the disability community recently commented to them that given the ruling in the lawsuit about mask requirements on planes, that it was now illegal to require mask and testing at in-person events, which is something we have been doing at our convenience. And so they would like your thoughts on this.
Yeah, first off, apples and oranges, they're two different things that we're talking about here. The federal mask mandate on planes and other public transportation was shot down because the court said that the federal government didn't have the authority to do that. As you probably know, in our constitutional system, kind of all authority devolves to the states unless it's expressly carved out, with federal authority. And the court said that the federal government exceeded its authority, did not have the authority to do that. That ruling has absolutely no impact on an ability of a private nonprofit organization like yours to impose a mask mandate at its events or a vaccine mandate at its events. Now, so that's fine. You can forget about the ruling about planes, trains, and buses and all of that has no effect on your meetings. You can continue to do that from a federal law perspective. But from a state law perspective, states do have the authority to do things like that. Now, we've seen some issues with schools, but outside of the school context and maybe some other context, I'm not aware of any states, and I could be wrong because things change all the time. I'm not aware of any states that ban a private organization from imposing a mask mandate. But there are 5 states at last count, and again, it certainly could have changed since then, but there were 5 states whose law, Florida and Texas, 2 big ones, along with North Dakota, Iowa, and Alabama. Those 5 states have a ban on businesses in the state from requiring proof of vaccination, COVID vaccination, as a precondition of entering the business. So for instance, a hotel in Florida or Texas is not allowed to say all guests coming into the hotel have to show proof of COVID vaccination in order to come in. That would be illegal. What is an open question? And we thought it wasn't that open until recently with a high-profile case. But we thought previously that even though a hotel based in Florida, for instance, could not require proof of vaccination for people to come into the hotel, that a private nonprofit that's holding an event, a conference at a Florida hotel, which is just leasing space from the hotel, it's not the Florida business, it's just leasing space from it for its event, that the nonprofit could require proof of COVID vaccination as a precondition of entering the conference. And many, it's anecdotal, but many hotels in Florida and Texas have told nonprofits and associations and others that were holding events there that they are free to require proof of COVID vaccination. But then there's this case that came along in Florida involving the Special Olympics, the National Special Olympics Organization. And again, I don't know exactly how this has all played out, but apparently whatever the Florida agency is that enforces their law, either slapped or threatened to slap a huge fine on Special Olympics for requiring COVID vaccinations for an event that they were going to hold there. So all I'm saying is it's a bit unclear how these laws are going to be applied. On their face, I've looked at all 5 of the laws. They're very brief. They just don't have much detail at all, and none of the state agencies in those 5 states have provided any more guidance on how they're going to be applied. All I would say is that if you are planning to hold an event in one of those 5 states, first thing I would do is check with your hotel or convention center, wherever you're holding it, and ask them, is it okay for you to impose a COVID vaccination requirement? And if they say okay, you should generally be fine, but I can't tell you that there's no risk. As you probably know, the Florida executive branch under Governor DeSantis has been extremely aggressive, as has the Florida legislature, in not only passing new laws and executive orders in a variety of areas, but in enforcing them very aggressively. So I would say, especially in Florida, there's definitely some risk if you were to do that. But check with your hotels, maybe ask them to check with their lawyers. This is not going to be the first rodeo for any hotel. Most bigger hotels in Florida and Texas are used to hosting, organizations, national organizations come in all the time to hold events. So the 5 states are Florida, Texas, and then North Dakota. Hold on. Make sure I get it right. North Dakota, Iowa, and Alabama.
Thanks for that, Jeff.
This next question was a long one.
Yeah.
You're gonna shorten it?
Well, I was going to go to the Florida question since we're on the Florida theme.
Okay.
Maureen's here. Had
Oh yeah, that's a good
Florida
idea.
about the Stop Woke Act, which is the one where putting a lot of limits on organizations being able to provide DEI training. And so even though the Funders Network, the Marines at, they're just under the 15 employee limit that this would apply to. They're obviously looking at this. Maureen, I don't know if you want to share more about this. And there was just an article in the Chronicle about this like today.
Exactly. The law goes into effect July 1st. And so as we're learning more about it as a Florida nonprofit corporation, even though we work nationally, we kind of had, 2 immediate questions or things we're thinking about. One is that it applies to organizations of 15 people or more. We're at 14 with aspirations to grow over time. So how do we kind of manage and look at this over time? And then the second is just kind of raising a much larger, maybe even philosophical at this stage, bucket of questions around, being incorporated in a state that's on a particular type of trajectory and what that means for us over time and what we might want to start thinking about. So they're both kind of 2 philosophical questions to a degree.
I'm able to give you with the second one. You're gonna have to work through that yourself. But first thing I would say is interesting. You mentioned Florida Nonprofit Corporation. I don't think your Florida nonprofit corporate status has any bearing on this. The law is not. There are some laws, like for instance, the California Nonprofit Integrity Act, that even if you're not based in California, if you're incorporated there, the law is going to apply to you. Here, though, this law, and I, I'm pretty familiar with it because we've been getting a lot of questions about it. Again, it's a really, like a lot of these laws that I'm talking about, it's very poorly drafted. It's got some real ambiguity to it. There's even, in our view, an open question as to whether that 15 employee limit really does apply here. I think you can make an argument that applies to all Florida employers, but all the articles that we've read, like by other, like Sherm and other law firms and whatnot, and that do a lot of employment law work in Florida, they all seem to be presuming that it only applies to employers of 15 or more employees. But regardless, your nonprofit corporate status as a Florida nonprofit is irrelevant. It's where you're located. But the law is also like that. The law I was talking about that prohibits Florida businesses from requiring proof of COVID vaccination. By the way, I said it that way specifically, just jumping back to the other issue, because it doesn't require that. It doesn't say you can't ask that people be vaccinated. You just can't require proof of vaccination. I guess you could do like a self-attesting. But that law, it applies to the Florida business. This law it's actually really principally directed at students. That's what, this primary focus is, but they made it much broader, and it applies to employees in Florida. So it's not even the employer, it's the employee. And so why this matters is that, especially with all the remote work situations that everyone has, and I'm sure we all know people who have relocated to Florida for a variety of reasons, some of which involves the weather, some of which involve politics and whatever else. But if you have a remote worker in Florida, even if you're based in another state, that employee is going to be subject to the protections of the Act. Again, presuming you have more than 15 employees. So it, and another thing to note about it is that this does not just apply in the employment context, it also applies to certification programs and other like accreditation programs, certification programs. And what it says is that if the DEI training, and it's not all DEI trainings are prohibited, just DEI trainings that the law gets into great detail about what's prohibited, but basically in a bad summary, it's basically, diversity trainings and other things like that make people feel uncomfortable for, the actions of certain races in the past. It's far more than like critical race theory issues. It's a lot broader than that. But it's something most like employer-based DEI trainings do touch on those issues. And so, if you're covered by the law, you guys, arguably not right now because of the 15, you're not 15 employees, but you will be once you get over that. Then, you have two options. One is you can try to scrub any mandatory DEI trainings that you have for staff so that they don't cross over the line. And I'm sure there are going to be plenty of Florida employment lawyers that get very good at showing you how to do that. Again, I was quoted in a publication called CEO Update a couple months ago when this law was first passed. And one of the things I said in the quotes was that, look, and we see it all the time with employment laws, even if you do your best to scrub it, if someone wants to bring, an aggrieved employee gets angry and they want to bring a claim or file a complaint with the Florida agency that enforces the law, they're likely going to do it anyway. But at least you put yourself in a stronger position if you try to scrub your trainings of anything that would be prohibited by the law. The other thing you can do, and it's far from ideal, and it really is counterproductive from a legal perspective in other ways in terms of protecting you from discrimination claims, would be to not make it mandatory. So the law only applies to mandatory, DEI training, certifications, so if it's not mandatory, then the law doesn't apply. And neither one is a great solution, to be honest. But don't blame the messenger. I didn't write the law.
Thanks for that.
Thank you.
I'm here, somebody zooming from Florida, so right now. I think this next question, this was raised in a CEO listserv, Jeff. Yes, everyone's welcome in Minnesota. Thanks. I think I want to ask two things. I want to pull out two things that are related around workplace. One is there's a situation where an employee was not happy that somebody else was in their office with a religious practice in a room on their own that they did not think was appropriate to be having in the workplace. So and they wanted to have a formal discussion about this. So for me, there's two things. One is what are sort of legal issues around religious practice happening in your workplace? Even if this was somebody who was not on their staff, it was someone who was there. And the second thing is that someone asked for employee asked for a formal discussion. And is there such a legal thing as a formal discussion? And how is that different from a formal grievance? If that such a request came in. Okay. So I guess you may have other things you want to talk about in that long.
Yeah, no. I agree with breaking it down like that. So the first one, and this is an ever-evolving area of the law, even as recently as this past Monday with the latest U.S. Supreme Court ruling about the football coach who said the school could not prohibit him from engaging in prayer in the middle of the football field after a game, before the game, whatever it was. This U.S. Supreme Court is continuing to expand the freedom of religion under the First Amendment. And so that's something to note. So first off, that the person who is in the workplace, who is not an employee, they're not subject, Title VII of the Civil Rights Act doesn't apply, to guests, to independent contractors, to, members. It only applies to employees. It applies in certain other contexts like higher ed and whatnot, but it only applies to employees. So that person is not subject to any legal protections, for freedom of religion under the First Amendment. So for instance, if the organization wanted to say, no, you guests are not allowed, to pray in our offices, they could do that. I mean, unless there's some, state law that a unique state law that I've never heard of that would ban that. But again, even the state employment laws are not going to protect a non-employee in that situation. So I think the organization would have freedom to ban that person from engaging in prayer in their office. Now, whether they want to do that, whether that's an appropriate thing, presumably the person is, a friend of the organization, and if they can provide them with a private space away from everyone else to do that, I mean, I can't imagine it really being an issue or problem. But from a purely legal perspective, if the organization wanted to ban that person from doing that, they could. If the person was an employee, whole different story. And there's plenty of precedent that says, for instance, say, like in the Muslim religion, if you're religious, you engage in prayer multiple times a day. And there's plenty of cases that say, like, an employer, there's a Muslim employee that wants to pray, has to kind of provide an opportunity and space for them to do that. And so there's great protections, longstanding protections for religious freedom. You have to be extremely careful. If it's an employee and they want to do that, even if it offends someone else. So say this example involved two employees, one wanted to pray, the other one was offended at the prayer. There is no question you are going to side with the employee that wants to engage in prayer, and just try to do it in a way, where they have privacy and whatnot. But if someone else just gets agitated or offended by that, there's no legal protection for that. And you absolutely have to make sure you protect the employee's religious rights. I hope that answers that first part of the question. In terms of the second part, so many people get caught up on, formal complaints or grievances in the workplace versus something else, and it doesn't matter. Yes, should you have, from a best practice perspective, like a whistleblower hotline? Should you have multiple reporting mechanisms, people ways to report harassment, discrimination, things like that? All those are best practices, absolutely. But I do a lot of like internal investigations. I call them investigations. Sometimes it's just talking to a few people and coming up with some recommendations. Sometimes it's a lot more. Sometimes involving the workplace, sometimes involving nonprofit conferences and things that happen there, always with alcohol involved. But in the workplace, and frankly, in all of those, but the rights are much more protected in the workplace. While you should have those formal grievance and reporting mechanisms and alternative means, so that, for instance, if the CEO is the one who's accused of harassment or discrimination, that the reporting doesn't all go through the CEO, something along those lines. But still, even if someone makes some informal or doesn't go through on a formal procedure, or just says something verbally, it's all the same. It all has the same legal force. It puts the employer on notice of a potential legal issue. And if they fail to do something about it, the employer might be held liable. And so if you learn of it, from any way, formal, informal, verbal, written, doesn't matter. You should treat it all the same and go through the same protocol of, asking questions and assessing credibility and, maybe bringing in outside counsel if you need to. And whatever else, to get the appropriate resolution. So don't get caught up. While you should have, formal reporting procedures for grievances and complaints and whatnot, you should not only deal with matters that come through that formal process.
And so in this particular case, when the employee asks for formal discussion, you should treat it like whether it's the same thing as a grievance or
have the
complaint?
discussion, consult with legal counsel,
Mhm.
have the discussion, and then, figure out the appropriate resolution.
Great. Susie, so you have your hand up.
Thanks. I think yesterday we were just all glad we weren't Sammy when we saw that. But that's who asked the question, Jeff.
Okay.
I guess I would like to bring the two issues back together if we could, to just understand the interplay here. So I completely heard what you said, Jeff, like it's all the same. Okay. And then I also heard what you said about that an employer can do that even if another employee is uncomfortable. So in this particular case, could the employer just say either directly to that person or like at a staff meeting as a reminder to everyone, we believe in inclusion, we make this available to everyone, and essentially get over it?
Well, first off, remember, I changed the fact pattern in the actual question that the individual who was praying was not an employee, but I changed the fact pattern to make it an employee because that's probably much more likely to be the scenario in most cases. And in that situation, yeah, it's not just that we believe in, inclusion and inclusive practices, it's the law. It's protected under both federal and state law. And yeah, I would say, I don't know if get over it is exactly the words that I would use.
Nor are they the words I would use. I'm being flip.
But no, I know.
But
Essentially, yes. And like I said, try to do it in a way, both for the, protection of the individual who's praying, as well as, for respecting others. You probably don't want to have a distraction to the extent possible. So if there's a way to have a private office or something like that, or allow them to leave the office if they want to, a time to do that, whatever else. But yeah, essentially the other employees have to get over it. And then it always, raises questions, because sometimes that's a slippery slope with some employees where they start, other employees start, making, critical comments about, the individual who's, expressing his religious beliefs. And all of a sudden you might end up creating a hostile work environment, based on religious practices that can itself create a liability risk for the organization. So sometimes it's more than just saying get over it. It's sometimes doing DEI trainings, at least if you're not in Florida, and other things like that. Giving warnings to employees that this is unacceptable. Everyone's rights are protected under the law, and we enforce those very vigorously. And if you don't honor that, you can be terminated.
Thanks, Jeff. Thank you for that. Really helpful. So Michelle, you had, I think, a couple questions, but they got cut off. And I wanted, I only got the first one, with which Jeff said he probably couldn't answer, around related to aiding and abetting related to abortion access. Jeff said, I think, that he couldn't answer that one.
Yeah, and that's kind of outside of my.
But were there others you had? I just wanted to ask if you had something else that got cut
Yes,
off.
I'm trying to remember now. One was generally, and we've taken time on it before, so if there are any other questions, this is just, we're in the process of doing our first fiscal agency for a member, and just what our legal questions came up in terms of liabilities for our board of directors. Did they need additional insurance riders? And are there general questions we should be asking from a legal perspective when we are going to do the accounting for a project that is not our own? Yeah,
so and by the way, I should say, back to your question about, could your organization get in trouble for some of these aiding and abetting laws relating to abortion access? I'm not in any position, and like most lawyers aren't, to give guidance on that right now, because this is also brand new. But for those states that have or will be, have strict laws banning abortions in the state, there will be issues. I mean, you've already probably seen there was a list of a whole bunch of big, like Fortune 100 companies that have announced that they're going to, pay for employees to be able to go to other states to access abortion services. It's going to be very interesting from a legal perspective to see how this plays out in terms of what our employers allowed and not allowed to do. But again, I'm just not in a position to opine on that yet. As to your question about, you say fiscal agency, I assume you mean like a fiscal sponsorship arrangement, right, Michelle?
I've been told that those are two different terms. So we will not be doing the work. We will not be, I won't be supervising the contractor, but we will be processing the payments for them. So
There's a variety of different types of, I lump them all under fiscal sponsorships. There's a
Okay.
variety of different types. And what I was going to say is part of the answer to your questions depends on the type of arrangement that it is, right? And we have a lot of clients that do a lot of fiscal sponsorship programs. One of them, the National Conference on Citizenship, they're always coming to us with another variety of, I can't believe how many different varieties of fiscal sponsorship arrangements they have. And of course, there's lots of legal implications there. But if you're just essentially, so basically, another organization maybe doesn't have its C3 status recognized yet, and so their contributions are going to be run through you. Is that right?
sort of a statewide project that doesn't have an organization yet. Lots of funders want to work on it together, and they want to pool the funds with us.
And then who's going to actually carry out the program?
They're hiring a contractor to do that. So someone that's going to be.
Well, who's they? Who's they?
They are so there's an oversight council that includes our members that are funders and includes experts in the field. This is to create a council on aging for the state. To eventually do lobbying work. So I know when they get to that work, we have to track that. But otherwise, I wasn't sure if there were other questions we should be thinking about.
What I'm getting at is the they a separate legal entity or not? It sounds like
it's a coalition. So no, I think that people are doing this with their official roles with those organizations. So AARP Missouri is at the table, but it is not AARP Missouri's program.
Yeah, so, one fiscal sponsorship model that's common is, say a new organization like that comes around, they form as a nonprofit corporation in Missouri, and then they've, prepared all the other documents and they filed their IRS Form 1023 application to apply for recognition of their 501c3 tax exempt status from the IRS. But it generally is taking, 9 months or so at least to get those approved. When it's approved, it'll be retroactive back to the date of incorporation. But in the meantime, if, either donors who want a charitable tax deduction or foundations who can only give to other C3s, that's where, using a fiscal sponsor, essentially it's kind of a crude way of thinking about it, is renting someone else's tax exempt status for a fee, usually a percentage of the monies that run through it. Perfectly lawful, happens all the time. In that situation, though, it's you're kind of allowing your C3 status to be used, but there's another legal entity that's actually carrying out the program. In other models, your employees are actually running the programs. Here, though, you don't have any of that because you don't even have a separate legal entity. So, let's just say, and so you said they're going to hire a contractor, but wouldn't you actually be hiring the contractor? I mean, this loose coalition doesn't even have an entity that can contract with the contractor.
That's a good question. We were not planning on it, right? So we were setting it up where we would not be the person making that hiring choice, but we would certainly be the person paying the person.
Think about a contract has to have two or more parties, right, to a contract.
Yeah.
One party is the contractor, but the other party, if there's no legal entity, it's going to have to be you or one of the member agencies, and whoever is the one retaining the contractor is taking on some liability risk for the contractor's activities. That person's being hired as an agent of your organization. So there is potential liability risk that's created. If your board's asking, does this create additional liability risk for individual board members? I would say no. Your board members at least, because for a variety of reasons, including your corporate status itself as a Missouri nonprofit corporation. That provides a shield. They call it the corporate veil, kind of a liability shield between the liabilities of the corporation and the individuals that run the organization, including your board members. And then there's also indemnification, and there's directors and officers liability insurance, and federal and state volunteer protection laws. All of those things help to protect the individual board members. They should not be concerned about any added personal liability risk, but the organization, depending on the construct, And pretty much in any of the constructs, you're gonna be taking on some added liability risk. It's just the level of risk is gonna vary depending on which construct you use. And I would be sure, check with your insurance broker to make sure that your key insurance policies, in this case, presumably your D&O insurance, your commercial general liability insurance, probably your cyber insurance, maybe even property insurance, and make sure that they cover these activities. So like if you're the contracting party, generally speaking, if those activities create liability risk, you're going to be covered by that because they're your activity under the law, right? But if it's, another organization, say new nonprofit corporation doesn't have exempt status yet, they're not generally going to be covered under your D&O or other liability insurance unless you got some sort of endorsement, to the policy to expressly cover.
That is helpful. Thank you. And yeah, they'll be doing work that certainly wouldn't be covered by our existing plan because they'll be doing statewide organizing meetings and things like that we probably haven't included.
Yeah, and that's another thing too. So getting ready to do a webinar tomorrow with one of my colleagues on kind of the regulation of lobbying and political activity for 501c3s for America's public television stations and all of their member C3 stations. So a lot of the stuff is top of mind, but there are, both, there's the 501c3, which is virtually all of your organizations, at least the principal entity is a C3. And as you know, you're limited in how much lobbying you can do, and you have to track it and report it on the 990 and Schedule B and whatnot. Schedule C. And so to the extent that, if your entity, your organization is a contracting party and you're paying the contractor and that contractor is engaging in lobbying services, you need to track those. Those are going to be deemed to be your lobbying services, unless and until you get some new entity formed and then they're the ones paying for the lobbying services. So, and then you also have both federal and state lobbying disclosure laws that also have all different definitions of what's lobbying and require you to track. It's not a limitation on lobbying, but require you to track and report it. I can't remember if Missouri has a.
Oh yeah, Ethics Commission wants to hear about it, and they want to hear about it quickly.
You got to be aware about that. Aware of that too.
Thank you. And I remembered the third thing. I think it's probably very quick, if that's okay, Dave. Sure. How's our list? Okay. We're doing a bylaws refresh. And one of the things that we noticed is someone at some point started to throw in he and she or he or she pronoun wise. They didn't do it consistently and there's no they. And so we were first going to just do a quick update on everything. And then I wanted to make sure we weren't changing legal meaning. I had a nudge in the back of my mind that at some point, and it could have been 15 years ago, someone said that if you shift pronouns that it shifts meaning and be careful about doing it. And so we'd like to have inclusive language and we don't want to shift meaning.
I have never heard of that. No,
okay.
A lot of our clients have kind of that neutral language in their bylaws. And some have gone through to clean that up from prior years, but no, I don't see these are concerned. Now there are a lot of other issues. I just spent yesterday an hour speaking to the board of a new client of mine who's appointing a bylaws task force to do a big bylaws overhaul for their association. There are a ton, I do this all the time. We work on a lot of these bylaw reviews and overhaul, some bigger, some smaller, but there are lots and lots of much more important, from a legal perspective. I'm not saying that's not an important issue, but from a legal perspective, there's many, many important legal issues when it comes to bylaws. And it's frankly an area like we've never, in all my 26 years of doing this, have never looked at a set of nonprofit bylaws that didn't really need some overhaul from purely legal perspective, complying with nonprofit corporation law, from a best practice perspective, from a clarity, eliminating ambiguity, all sorts of reasons. Something that you should, really should focus on. I'd probably say at least once every 5 years.
Thanks.
And our process on that was to have the committee and the board look at it first and then have council look at the final draft.
I get that question.
That?
Yeah, I get that question a lot. I've been down that path a lot because sometimes clients do that and then they don't tell me and then they come afterwards. I strongly recommend against doing it that way. In fact, we're actually for the one I was talking to yesterday, we were just kicking off the process yesterday. But what we're going to do there is we're going to do our review first. And then, some of it's going to be recommended changes. Some will be comments where we're keying up like options or, this is unusual or not a best practice, but here's some other alternative ways to do it. So we'll kind of tee up the things, and then that the task force, usually most groups do it through like a board task force. The task force has the benefit of that as a starting point, instead of they do all this work and then they send it to us and we're like, there's some major issues and problems here, structural issues, things like that. That doesn't make any task force member happy. And it's also very inefficient too. So yeah, I either do it, sometimes we do it that way. And other times it's like in combination, we kind of work with them almost with, with us, one of us being kind of a consultant to the bylaws task force.
Thanks so much.
Thanks, Jeff. Susie, and then.
I'll just add that when we recently did it, we just had the attorney in the room with us while we went through it and highlighted the areas that we thought needed attention. And she just was sort of with us through that conversation. And then she went off and did the draft and sent it back for us.
Yeah, that's Susie, that's kind of the other way that we do it. Absolutely.
So one last question. Carla had a question about support for a corporate foundation looking to establish bylaws and governance. I don't know if there's resources you can direct her to, or in general, in this last couple of minutes, things you can share with her.
Yeah, I think, the Council on Foundations has some good resources. I assume you mean private foundation, probably has some good resources there. I'm not sure where else to. I mean, some of the groups in your world, like National Council on Nonprofits, might have. If that's still their current name, or the.
I think it is. Yes.
What is it? The Philanthropy Network, and others might have some resources, but. Certainly, though, if you guys, whoever asked the question, we do have lots of different model and sample corporate documents for nonprofits, a huge library of that kind of stuff, and always happy to help out.
Great.
Any final questions in our last couple minutes?
Yeah, we got 2 minutes, last chance. Any? Well, if not, I want to thank everyone for being on the call. Jeff, thank you. I always learn a lot on these calls, and so grateful for that. So I don't know can't recall the date of our next program, but we'll be sure to share that all with you well in advance. Or go to our website, you can see the next. And then
thank you. One comment, I just saw something in the chat from Susie. Remember that your bylaws have to be consistent with, of course, your articles of incorporation, but also with your state nonprofit corporation statute. That's when I said pure legal stuff. That's what I was referring to. And many nonprofit bylaws are not consistent with your state. And it's the state where you're incorporated, not the state where you're located, if that's different. And so that's a really important thing to focus on. And that's a key role of attorneys. But thank you guys for great questions. And I think we got Dave's been great at getting these on the calendar far in advance. So we have the next one scheduled in the next quarter.
Yeah.
Have a good few next months and next few months, and I'll see you soon.
Be well, everybody. Have a great holiday weekend. Good to see you all.
Thanks.